Welcome to this first webinar co-hosted by the World Congress on Family Law and Children's Rights and Law Asia. I'm Diana Bryant, Chair of World Congress. As many of you know, just about 2 weeks ago, we were all to be together in Singapore at the 8th Family Law and Children's Rights Conference. How the world has changed. But as the times change, so must we. So we're pleased to be able to present this webinar, which will showcase how the courts have been dealing with the pandemic and showcase some of the work which you would otherwise have heard about at the conference. Let me first introduce the panel, because we have a very august panel today. Chief Justice Alstergren, Chief Justice of the Family Court of Australia and Chief Judge of the Federal Circuit Court. Presiding Judge Ong from the Singapore Family Justice Courts. Ms. Susan Ackland Hood, CEO of the United Kingdom Courts and Tribunals. Assistant Commissioner Lisa Gale of the Australian Federal Police, and particularly part of the Australian Centre to Counter Child Exploitation, called ACE. Mr. TL Yap, a Singapore practitioner who's on the executive of Law Asia. Their bios are available to you. Thank you to those who submitted questions for the panel. I've attempted to include as many as I could in this session, but not all will be able to be covered, and we hope to have further webinars in the next 12 months. So if you have themes you'd like us to cover, please let Law Asia know. There's a Q&A function for questions, which depending on time, we may be able to get to. So let's get started. Chief Justice Alstergren, can you take us through the early days of the pandemic? What were the court's early experiences and how did you handle them?
Thanks, Diane. Welcome everybody and thank you for letting me be part of the panel. When we first it seems so long ago now, but it wasn't really that far ago. We were, like most courts, I think, operating virtually almost entirely on face-to-face hearings with some video conferencing between different courts and no external video conferencing. And we were doing effectively about 17,000 cases a year in the Federal Circuit Court and about 3,000 in the Family Court of Family Court type cases, trials and applications. Spanning over 17 different locations around Australia. I was in Sydney. We were in the middle of doing a big summer campaign to try and reduce the amount of court cases we've had in the backlog that were over 2 years old. We listed a number of cases in groupings throughout the day, and I had called over a number of cases and found myself on the following Monday in a restaurant with a couple of other judges. We've been, again, calling over cases and managing cases, trying to send them to ultimate dispute resolution. When I got a phone call, the phone call was from a security officer, the Marshal, who is a very apt fellow and very, very serious, and rang me up and said, "Where am I?" And I asked him, "Well, why do you want to come and join us? We're having dinner." He said, "No, I need to know the address." And when I told him the address, he said, "You must leave immediately. Who are you with?" And I told him, "I'm with 2 other judges and I'm with the head of the HR department." He then told me that was terrible. And I said, "No, it wasn't terrible. They're actually quite nice people." He actually said, "No, because you've all been exposed to the coronavirus, you must leave immediately and go and self-isolate." And that was probably the first time that we, to be fair, really realised the level of potential infection. We had to, rather than self-isolating for 14 days, luckily I was too far away, but we had a litigant that had come into the court and a solicitor who the solicitor had tested positive to the coronavirus quite early when it was first occurring. And it meant that we couldn't rely upon people not to come to the court with symptoms, even though we had signs everywhere saying, "Please don't come into the court unless there's a problem," because we'd had some problems a few weeks before in Canberra. So that got us into the reaction phase, if I can put it that way, where we had to basically stop all face-to-face hearings around Australia. Only allow face-to-face hearings in urgent cases for no more than an hour and a half, pursuant to some health advice, design a new in-court process where people were socially distanced, and we had to clean the court that we were actually in, have that deep cleaned, and we had everybody out of the court for 24 hours and then back in. And then within 2 weeks of that, we had to transform from a court which had never used Zoom or Microsoft Teams for anything else but social or business functions to suddenly actually conducting hearings. It also, as you know, Diana, didn't have any major files that were actually electronic. Most of our files were actually in paper form. So we had to very quickly establish a new electronic digital file base And luckily, thanks to the IT department of the federal court entity, we were able to transfer that and get 104 judges and 35 registrars across Australia onto Microsoft Teams very quickly. Then, of course, we had to teach them how to use it, which happened very quickly. And I think we've maintained about between 85 and 95% of the work we would have done previously, but through electronic hearings since then. I have to say, though, that the most important person in the court is no longer the Chief Justice. It's the head of the IT department.
Right. Did you have the funds available for that? Were the resources made readily available to you?
Yeah, we had. We didn't receive an extra funding. We just did it all with the existing resources we had. There were some IT issues we were able to gain. I think they had to get licenses for Microsoft Teams and things, but predominantly the biggest issue, I suppose, was rolling out some of the things like screens, keyboards, and other things, so judges could actually conduct hearings from home. So we weren't reliant upon people having to come into the courtroom. That made a big difference. But predominantly, a lot of the work, a lot of the resources we had came from internal resources, which was a challenge.
And what have you been running most cases electronically since?
Yeah,
then?
we started about 5-6 weeks ago with face-to-face hearings again. Unfortunately, in Victoria, that wasn't a great success. We've had to stop them. But in other states and territories, we've been able to maintain face-to-face hearings for trials and for applications. 6 courtrooms in each of the major registries are open for business, apart from in Melbourne. In Sydney, unfortunately, it looks like that may not occur for very long, but certainly from the other places we have, and for urgent cases, we've maintained for short applications a protocol with face-to-face hearings of no more than 2 hours. In Queensland in particular, in South Australia, they're pretty full bore with face-to-face hearings now, but obviously in some other states we've had to limit it.
How did the judges pick up the technology and be able to use it when many of them weren't used to it?
Yeah, well, I was probably one of them. I think it was interesting. I think if you'd asked me 3 or 4 weeks beforehand if it was going to be able to happen, we'd say not in your life. But what occurred was, just out of necessity, people picked it up very quickly. They were very eager, and a lot of them were very eager to do so. And I have to say, we're armed with some fantastic associates who are termed to be digital natives. And as a result of that, they've got no inhibitions whatsoever with using technology, whereas I'm a bit terrified of pushing a button. So they were able to adapt very quickly. And the IT department of the federal court, which were helping us, did a great job. We had a few issues, but we managed to nut them out. And it was really because everybody was forced to use it that it worked so quickly and so well.
Yep. I note that you released a statement that was essentially a message to parents, providing guidance about existing court orders and shared parenting arrangements. What messages were you receiving about the major concerns facing parents that led to that?
Well, unlike a lot of other nations, we had borders internally that were actually closed. And what was happening was a lot of people with shared parenting arrangements were unable to adhere to the conditions that either agreed to or had been ordered in the best interest of the child. That included visitation rights, it included supervision in supervision centres that now are closed, it included where people were going to drop off and collect children, where a lot of the schools were closed, and there was a lot of doubt, confusion, and perhaps in some cases misinformation. And I have to say that probably in most of the states, it wasn't clear at all whether the exemptions or restrictions that were put in place applied to shared parenting arrangements. So we had to work very quickly to make sure we educated the state attorneys general to make sure that they made it, the positions very clear. It helped with things like if you had international relocation cases and we had a recovery order where a child was brought back to Australia, you couldn't guarantee if the child was going to Brisbane. If it arrived in Sydney, it may not be able to go there. Or, for instance, if a parent wanted to go and visit a child pursuant to the agreement in a different state, that parent may have to self-isolate for 14 days. So we wanted to make sure people knew that we wanted them to try and to observe the spirit of the orders. We wanted to know that they sent them to try and get them to negotiate if they possibly could around those differences they had to make because of necessity, to observe the fact that it was in the best interest of the child. But if they couldn't negotiate a settlement, we wanted them to know that we were open for business. We were not shut. It was never an option for us to shut. We're an essential service. And we wanted them to let them know that they weren't alone. And it was, I think that formed it actually we got a great reaction from it and actually worked very well.
We've seen a lot, I think, about the concern about family violence and the particular pressure on families and women and children during the pandemic when there's been a lockdown. What in particular did you put in place to deal with family safety and risk assessment as a result of COVID-19?
Was a number of things we've been working on. We had already worked on a Lighthouse Project, which I'll get to in a minute, but we also looked at what people were experiencing in the coalface, and we had the women's legal groups in particular were very, very helpful in looking at what they were experiencing and how we could try and assist. They came up with the idea, which we endorsed, of having a COVID-19 list where people could, if they were affected by COVID and it was urgent, they could issue electronically an application in short compass within, and it was going to be triaged or heard within 3 days or 72 business hours. That has been an outstanding success. Just being able to give them an opportunity of being able to work out their differences. If they weren't adhering to shared parenting arrangements, did they have a reasonable excuse for not doing so? Was there miscommunication? Were there real serious concerns? But also in relation to risk assessment, we were able to look at what we could do electronically to try and assess risk as quickly as we could. This, interestingly, this particular list also gave us the opportunity of people being able to access the court electronically rather than having to come to court. Now, a lot of times when people, particularly women and children, but particularly women, when women were in a vulnerable situation, they could access the court by filing and then having a hearing electronically from their home, from a safe workplace, from a refuge, from a car, it didn't matter. And that's made a lot of difference. The other thing we have looked at is the advent, we were developing the Lighthouse Project, which is to do with risk assessment, and which is going very well. And we're looking at how we could try and triage those cases as quickly as possible. Electronically, it's made a massive difference to what we can try and do.
What about ADR and arbitration? Has there been an uptake in that during this time?
Yes, interestingly, a lot of parties, I think, have decided that they've got other things to worry about than their family law proceedings. So some of them, surprisingly, that have been ensconced for a long time have settled. We introduced a national arbitration list about a month and a half, 2 months ago, with a dedicated judge in each court handling that arbitration, and it's obviously in property matters only. That's been going exceedingly well. We've got Justice Wilson in the Family Court and Judge Harman in the Federal Circuit Court, and they've both developed a standard form of orders to make sure that arbitrations are heard, are determined as quickly as possible, sent to arbitration as well. It's one of those things electronically you can do quite easily, and there's a huge uptake in that. And also ADR. Interestingly, the profession took to ADR very quickly. They've done a great job with that, and we've got a new software system called iMediation, which has been utilised by the registrars through David Pringle, our Chief Executive Officer. We've signed a contract in relation to that, and that's going very well. So having the facility for electronic mediation is a huge benefit to us. And again, people don't have to be inside the courtroom to actually have this conducted.
Okay. During this period, what were the biggest challenges and your greatest fears? In other words, what was it that kept you awake at night?
Sure. I think there's a couple of things. One is really making sure the backlog didn't grow, that we didn't finish this pandemic and find that we had an insurmountable amount of cases and people's access to justice was really inhibited by that. But secondly, and so we actually had to make sure the communication was right and that we had a structure we could keep on operating on. Secondly, I was very fearful, and I still am to a point, that whilst people are in this restricted environment, domestic violence or family violence will grow. At the moment, there is a theory, or at least part of a theory, that whilst people have got some relief from an economic basis through JobKeeper and JobSeeker, which are government incentives to try and assist people while the pandemic is on, that was meant to dissipate, and it's dissipating at a particular point in sometime later in the year. There is a fear that once that starts dissipating, people have got less money, you may find, and restrictions start easing off, you may find that in fact domestic violence does increase. So we want to make sure we put everything in place we possibly can to keep a handle on that and make sure that when cases come in, certainly we can identify the risk, but also we can make sure that we can information share between the states and the Commonwealth courts to make sure that we can handle these cases as best possible and make sure they've got the best resources available to them. They're probably the two biggest things at the moment.
Thanks, Chief Justice. Presiding Judge Ong, I know that Chief Justice Menon would have liked to be with us today but wasn't available. Can you give us some idea of his leadership of the Singapore judiciary during COVID-19?
Thank you, Diana. Yeah, our Chief Justice, as you know, is a visionary, and he thinks many steps ahead, very far ahead. Some of us might think that visionaries are usually up in the clouds, but this chief is right there with us, and his leadership has been steadfast and decisive. So when the pandemic hit us, the very first thing that our chief did was to form a COVID crisis management team. And in this team, we had the presiding judges of the state courts and FJC, and that would be me, the registrars of the state courts, the family courts, as well as the Supreme Court, as well as the CEO of the Supreme Court. Of course, our chief officer in charge of technology and innovations and transformation was part of this team, because technology obviously was going to feature as a very important aspect in resolving COVID at this time. And so we met, we had meetings by Skype, and Chief would receive updates from us, and we would plan out how each court would operate under the restrictions. And we would draft registrar circulars so that we could be clear with how we were going to conduct matters and which matters were going to have priority and which had to be deferred. I'll just say a little bit more just to give the context, since, you know, this is Singapore, and we have used the word circuit breaker instead of lockdown. We had 2 periods of the circuit breaker. It started with 1 month in April and was extended for another month. So we had 2 months of circuit breaker, or I'll just call it lockdown because that's what the other jurisdictions use. During this time, only essential services and the key economic sectors were operative. In the first month, the courts heard only urgent and essential applications. So clearly we would then have some backlog, right, that would arise because of this reduced hearings being conducted. In the second month of lockdown, when it was extended, we extended the number of cases to those which became urgent or more essential due to the passage of time. And so during the 2 months of lockdown, for the family justice courts, the family courts worked very hard still and managed to still clear or still dispose about 1/3 of the normal load during the lockdown periods. The Chief Justice also identified a few broad areas, about 6 areas, that we were to look more carefully at. And one area, for example, would be how do we recover the backlog? And I hear William also that was something that kept him awake, backlog. How do we recover? What legislation was necessary in order for us to conduct our business in the new normal? Also, what training, what technology-related resources we would need. So there were some broad areas, and Chief got some of us together, and we worked on each of these streams of concerns or work. And our chief is a really powerful thinker, so he sets out papers, he makes it very clear, and I think we're always just ahead.
Tell us a bit about the family justice courts then, if you would, Debbie. What particular challenges did you face in the family justice courts?
I must share with you that apart from remote hearings, and I think that it's quite clear that many of us went to remote hearings, and what we did also was like what every other court did, try remote hearings. Now, even before the circuit breaker came into force, Chief had already got us working on how to enhance remote technology. So using case conferences by telephone, trying out remote hearings, these were all being built up. And actually, even before the lockdown came about, we were split into 2 teams. So in the courts, we had the yellow team and the pink team. And this was to ensure that if someone in one team, for example, had to be quarantined because we have very strict COVID measures, and if we had been in contact with someone who was tested positive, then actually quite a large group of people who had contact would be quarantined, and we didn't want the entire court to shut down. So we worked in two teams, and we could not talk to each other physically. We could not actually lunch with each other and so forth. So we kept our physical interactions at a minimum. So we had the split team arrangement. Now this continues today. We work in two teams, and even in meetings, we are not to have anyone mixed between the teams. So we largely have video conference meetings. In respect of the family justice courts, of course, we had concerns on, for example, whether litigants in person would be able to have hearings by Zoom or teleconferencing. I mean, some of the litigants in person without the help of lawyers may not have the equipment, may not know how to use Zoom, or maybe in a situation where they don't even have the equipment. Could be that they are poor, they are unable to, or they are unable to find a private space, supposing there's some pressure or family violence at home. It's not going to be easy to hide in a corner of the toilet to call out or to get help. So we're aware of this. So the family justice courts provided 14 Zoom rooms. So we have 14 physical Zoom rooms in the courts, so that if we had any litigants who needed to come to the court to use our Zoom facilities, because the judges may be at home, right? So the entire hearing is already conducted remotely. So even if the litigant appears in court, there's no physical hearing, but we provide the Zoom rooms. So these Zoom rooms have been very supportive, and we give them 20-minute training as well, sort of mandatory training, of course, with safe distancing. We give them manuals, we give them videos and so forth, so that they are able to manage these hearings. Apart from that, well, I must say that we have in the lockdown periods largely conducted hearings remotely, and even now post lockdown, we still do. I mean, maybe more physical hearings, but still by default, it would be remote hearings. This is to ensure sustainability, and we want to really keep our nation safe. We don't want a court cluster, for sure.
And what was the greatest challenge that caused you the most angst during that time?
Okay, of course, like Chief Justice backlog. Every time we do not fix a case, we know that the backlog grows. And of course, as a presiding judge, I think also about my court staff and my judges. And I'm thinking, when we are out of this lockdown, how do we clear the backlog in a way that will not kill all the judges? I mean, we all need to be well. We can't overwork everybody, and we need to cope, recover, and yet be well. I think there's also some research that tells us that judges are more fatigued when they conduct hearings by remote means. We also do not have the court support around security, physical bundles, that sort of support. And so if there are technical issues, the judge will have to go through, okay, can you turn off this? Can you do that? All right, can you switch off the video? And it's tiring. And while we are really lucky that our case files are all on an electronic file system, and so we can access our files from home, it's not quite the same. I mean, right now I have about three monitor screens in front of me. So you've got to manage, you've got to toggle, and you've got to manage the Zoom computer, the e-litigation is what we call it, as well as type your minutes, sheets, and so forth. So that was also worrying for me. I wanted my judges to be able to do their work well in an environment that was that could enhance efficiency, but should not compromise health and so forth. So that was my constant worry at the initial stages.
Thanks, Debbie. Susan Ackland-Hood, can you take us through the early days of the pandemic for the courts and tribunals in the United Kingdom? What were the early experiences and how did you handle them?
Yes, thank you very much. Good afternoon, Diana, judges, Lisa, and everybody watching. Yes, so if I just talk briefly through what happened in the early days of the pandemic in the UK, it started to become clear in the middle of March that there was something here that we were going to have to react to in a very significant way. We had some standing business contingency plans, including some that were focused on pandemics. And the first thing we did was get our plans out of the cupboard and dust them off. And I think in retrospect, the first thing I would say is that our plans were far too focused on the impact of people being ill. So the plans were really fundamentally about how you manage a system in which you have a certain proportion of people who employ who are ill. And so we were really looking at how do we run the system with a reduced capacity. And the plans didn't cover sufficiently the impact on our business of lockdown and social distancing, which have turned out to be much more fundamental impact on our business than actually the number of people who were ill. So throughout, we've actually had really quite small numbers of HMCTS staff and judges who were themselves unwell. And I think there's an interesting forward piece of learning. But anyway, we got those plans out of the cupboard and we stood up our HMCTS Gold Command, which is our response team for emergencies, on the 16th of March. And on that same day, we also provided all staff with the first draft of a revised business continuity plan that was more COVID focused. And if I tell you that we're currently on version 12 of this plan, I think you might see one of the challenges that I'll talk about when you ask me your sleepless nights question, which is I think one of the challenges of the pandemic has been that the situations change repeatedly. So your response has to keep evolving and developing as those circumstances change. The first thing we did during those very early weeks, even before the UK went into full lockdown on the 23rd of March, was really focused on trying to get our capacity to do virtual hearings and to do work differently going, but also to make sure we had a really clear set of prioritised case types. So one of the things that was included in that original business continuity plan was a list of case types for each jurisdiction agreed with the judiciary in advance, which told us what our most urgent types of work were. And the intention wasn't to stop particular types of work, but just to make sure that if we had reduced capacity, we knew what we were hearing first and what we were prioritising. On the 19th of March, Sir Andrew McFarlane, who was the president of our family division, issued guidance aimed at keeping the business going safely, and that provided the default position that in the family jurisdiction, hearings should take place remotely if appropriate to do so. So the other thing that we were doing was trying to kit ourselves up for more remote hearings. We've always used quite a bit of remote technology in our criminal courts, but much less in our civil and family courts. We were starting a set of pieces of work as part of our reform programme with a very nice suite of technology to deliver full video hearings, but it didn't have the capacity, it wasn't yet ramped up to be used very widely across the system. And so we did a set of tactical things in those first weeks. We had Skype for Business installed as a default on every judicial and staff laptop in HMCTS, but it wasn't unlocked. It couldn't talk to the outside world. It was on there designed to be used for internal meetings. And so I spent probably, 2 or 3 days having a small battle with the security team in the Ministry of Justice's IT department to get them to unlock Skype for Business so that we could immediately start to use it outside our walls as well as inside. By the way, they were incredibly helpful and supportive, but they were also making sure they did their job and tried to safeguard our system. And we also went and massively expanded the number of licenses that we had for our phone hearing system, which is a particular system that includes recording functionality to make sure that we have recordings that meet the standard of the court. And we had a set of licenses for that, and we used it quite a bit, particularly in civil hearings for preliminary and progress hearings, but we ramped up the number of licenses, I think pretty much in that first week, so that we could hear, so we effectively had a license for every courtroom in England and Wales that was available if one wanted to do audio as well as through Skype. So it was definitely a tactical response rather than something that was more strategic. We also started the business of distributing laptops to our staff. So the other enormous challenge we had, so a little bit like Lord Justice Stalgren, we still have a lot of work that goes on in our counter courts and civil and family courts that is paper-based. Even where we had things on digital systems, the staff were desktop bound. They had desktop computers, part-time, so people will work on one computer. And we started the business of laptop distribution, which has resulted to date in the distribution of close to 9,000 laptops across HMCTS since the beginning of the pandemic. That was a huge logistical exercise, and the first ones were able to be delivered to people's homes in that kind of first couple of weeks, but it took us some time to get the supply chain to flow through to get us that full 9,000, particularly at a time when pretty much everyone in the world was in the business of ordering laptops. So following on from that, we worked in that way for the first few days of the pandemic, and then a week after lockdown, we moved to reduce the number of court buildings that we were operating from physically. And that was because we were increasingly trying to do as much work as possible remotely, but we were also very concerned that where we did have physical hearings, and we kept physical hearings going in every jurisdiction to some extent absolutely throughout, because again, as others have said, we're an essential service, we can't close down. But we wanted to make sure that where we were doing those physical hearings, we could do those from really safe, secure sites where we knew we could implement social distancing and where we could make sure we had the staffing, including things like the cleaning staff and marshals, to make sure everybody was safely accommodated. So for about 2 months through April and May, we operated with a reduced network of about 159 open sites. We had a further 114 sites that were staffed by judges and staff, but were not open to the public, and they were effectively hubs for doing those remote hearings where it was easier for the judges and the staff to administer them from a court building rather than from home. And we closed 68 courts altogether, and we operated that reduced model through April and May. On the 18th of May, we resumed jury trials, having suspended those on the 23rd of March. And we started with very small numbers because a jury trial gives a particular set of challenges for social distancing. But throughout May, the numbers of physical hearings we were doing were increasing. And then at the beginning of June, we started to reopen the staffed and suspended courts. And we now have all but a very small number of our courts open and serving the public. The ones that are not open tend to have very particular issues associated with them. Either they are incredibly small and tightly organised, and we cannot socially distance in them, or they have other issues that in a sense might well have meant we took them out of circulation, even if that had not been a pandemic. The key things that so just turning to the family jurisdiction in particular, the judges in the family jurisdiction moved incredibly quickly to embrace remote working under the leadership of Adr and Arbitration. And we saw huge numbers of remote hearings starting to take place very quickly. Again, it was both video and audio, and early on, in total across the system, there were probably slightly more audio than video hearings. The balance has shifted as we've gone on, people have got more accustomed to using video. But at the peak of the pandemic, the whole court system, about 90% of the work that we were doing was being done remotely. And the other really remarkable statistic is that in the family jurisdiction, we use a currency judicial sitting day to look at the amount of work being done. When we reviewed the sitting days over this period, we found that the family judges had sat around 98% of the expected allocation of days. So they had done as much work as would have been expected during that period if we hadn't been going through this. Now, they haven't necessarily been able to use those days to dispose of as many cases as normal. Actually, in public family law, those cases that involve the safety of children, they have come pretty close. But private family law has seen more cases adjourned and waiting, and continue to look at and refine that triage that we did at the beginning to make sure that we're always hearing the most urgent cases, but also that we're able to do as much other work as possible. And then finally, the other thing we have tried to do is to start learning and embed it in the way that we're working right from the start. And so there has been work, including with the Nuffield Family Justice Observatory, to look at the experience of those remote meetings. About halfway through this period, there was work that looked at specifically at what types of work were working well remotely and what types of work really needed attendance in person to be as effective as possible and as fair as possible to litigants and others. And that means that the family jurisdiction is now using more physical hearings for those cases that need them, but is also looking at using what's described as hybrid hearings. So in some cases, professionals are keen to attend remotely, but families may be keen to attend in person and to see the judge face to face. And actually that supports us in social distancing in the courts. It also means we can try to ensure fairness and safety, which of course are the two things that we've been pursuing throughout.
It seems from what the three of jurisdictions have said is that the funds have been made available by the government to support the use of technology and acquisition of hardware and so forth. Did you have any difficulties with that?
No, we didn't. So we had the British Treasury gave a kind of relatively blanket position across departments that up to a certain limit you could spend on COVID-related things without checking back, and we used that, and then we were given funds relatively recently during July, which recognised both some of the spend that had happened to date and gave us some more provision going forward, particularly for continuing to expand and develop the digital technology. So I should have said we started with this quite tactical unlock Skype and just let people use it. We've since been rolling out our cloud video platform, which is a much better adapted platform. It particularly is important in the criminal courts because it allows connections to the closed networks that police stations and prisons have, which was a challenge with Skype. And in the family and civil jurisdiction, it contains its own embedded high quality recording functionality. And that's been rolled out across all of the criminal courts already and is in rollout in the civil and family courts now. And just to give a sense of scale, we've already done well over 10, again, this is criminal because it's more embedded there, but we've done well over 10,000 remand hearings using that platform since the pandemic began.
And how did the judiciary take to the technology and the profession? Was there training required? Was it difficult?
So I think the answer to that is it depends very much on individuals, on leadership, and on some of the, we've had great support actually from some of the professional bodies. So the first thing is, as soon as we unlocked Skype and Meet Me, we had practical guidance for staff and for judges that went out as fast as we could to help people with kind of which button to press next. We had some people who needed more intensive support than that, and we were trying effectively to direct that more intensive support in the right places. We also had really good support from the Bar Council and the Law Society, who did quite a lot of work with their own membership to try and make sure that people understood what would work, which products were compatible with each other, and so on. Then with the cloud video platform, as we rolled it out, we've done a lot of training on that as well. And I think adoption has been, as I say, the family judiciary, I think, have taken to it particularly well and early and quickly and have done huge numbers of hearings. The criminal judiciary were more used to video, but not necessarily all of the modes and platforms that we were using. With the profession, I think there's been a really interesting, I think there's genuinely been a bit of a revolution in the sense that most of the profession are now telling me that they're very, very keen that we retain this technology going forward, and that they'd like to see more hearings, particularly preliminary and progress hearings, where it feels very disproportionate to travel for short hearings, and are keen that we would take that. And as we move back to physical hearings for some things, I'm getting a lot of pressure from the profession for more use of video rather than less, which, and if I was completely frank, if somebody had told me in February that one of my problems in July, August would be a clamour from the profession for more use of video, I would have been very surprised.
And finally, what kept you awake at night during this time?
Or
continues to?
I think it's partly, so I echo things that others have said. So I clearly am worried about backlogs and the cases that have gone unheard. I think, again, to some extent in our family jurisdiction, we already had some pressures. We had a huge increase in volume over recent times, and recruiting judges, it's difficult to recruit good quality judges as fast as the volumes can sometimes increase. And so that was an existing concern which has not been made any better by the pandemic, although thanks to the efforts of the family judiciary in particular, it is not as much worse as we might think. So I worry about that. I continue to worry about the quality of the justice we're able to offer, and making sure that we really are doing the learning from this. It has been described as a kind of biggest natural pilot in the world, but it's also an incredibly difficult pilot to evaluate because so much else in people's lives has changed. So working out what is the impact of remote technology or different ways of working, and what is the impact of the pandemic, and what is the impact of the fact that you're trying to do your remote hearing with your poor children in the room behind you, and what is the impact of the different lines of people. It's really difficult to untangle, but I feel as though if we don't successfully untangle that and do the learning, we really won't have taken the silver lining from this cloud that we should have done. And then I referred to it earlier, but the fact that we are existing in an environment of constant change where you cannot, it feels as though we've been sustaining the kind of pace of innovation and ask of our staff and of judges as well, that you would normally expect in a short, sharp shock of a crisis, but we have done it for months, and looking forward, we're going to have to continue to do it for months. So holding on to people's well-being, energies, and still serving the public as well as we need to, I think is still a real challenge.
Thank you. Mr. Yap, let's hear now, can we, a bit about the profession. How have things changed for the profession in the way that you now interact with courts and with clients?
Thank you, Diana, and good afternoon to all the participants in this webinar. I think the profession has changed drastically in the way we practice law, and in so far as changes are concerned, adaptive changes had been thrust upon the profession, and things we are not used to, and a new norm that has suddenly needed to transition from what would be the traditional way of practice has come about on us without actually any lead time. So you would have, and I've heard stories that law firms and lawyers may not have been equipped to transition to do things remotely, whether in their interactions with clients during the lockdown period or the circuit breaker period, and certainly where court hearings were concerned. Whilst in the past, the courts have had and explored telephone conferencing, video conferencing for some of the cases, remote hearings were not on foot. Hence, lawyers had to, the profession rather, had to make sure that they had the equipment to be able to manage that. And then you're trying to find a place in the home to try and do remote hearings. If you had a team with you, suddenly your team is not with you. They're doing it remotely, and you're suddenly having to do everything independently on your own. So those huge changes certainly did have an impact on the way we practice. Insofar as the courts are concerned, well, moving into case conferencing, we did that by telephone conferencing. Mediations moved into doing mediations via Zoom. We found that we had to collaborate more with the clients. We had to prepare the clients more as to what would be expected of them. and teaching them and how to adapt also to the new norm. More importantly, I think for the profession is BCP, the Business Continuity Plan. We really didn't know the extent and how COVID-19 would evolve, and the concerns of someone in your firm getting infected and how that would impact your practice was a huge concern. And if you are big enough to have 2 different teams or 3 different teams working remotely, that's fine. But I think in the smaller practices, a bit more challenging, where you actually have to do things on your own. And certainly the continuity plan, if touch wood, you get infected, would have grave impact on the firm and its practice, and certainly its clients. The other thing, I suppose, in relation to the profession, is now the change moving forward. So whilst that was more in the past, it is still evolving as to how we would practice, what we anticipate would come in the future, and how we try to prepare ourselves for that. And I think the Law Society of Singapore has also been very supportive of its members. They gave out regular updates, even on mental health issues, and certainly concerns of lawyers being able to take on board, right, the new norm and the sudden changes to what they're used to. So I think insofar as practice was concerned in the profession, that was, I think, the main changes.
Have you found any particular kind of cases have proved to be more difficult than others during this time?
I wouldn't say more difficult. I think the cases are par for the course, whether in COVID or not. But I think with COVID, the disputes arose more acutely in relation to access, for example, and handovers, particularly when lockdown first started. Even though the government came out with the COVID-19 temporary measures regulations, there's a lot of uncertainty and clarity being sought as to what happens in cases where there are court orders or agreements for access. I think in the early days, particularly in April or May period, these disputes came about, and in some cases, I think access was restricted, access denied, and those difficulties arose. And whilst we could make the application to court, and the court would certainly hear this being on an essential case, it still nevertheless, unfortunately, I think in some cases, some parties rightfully or wrongfully took a view, but at the end of the day, I think these were the new things that cropped up, which may not have happened with COVID, if had COVID not happened, for example. So yeah, insofar as relocation or asset division cases, I think those went on and carried on as per norm. There may have been some delays in the early days of COVID, but I think that's all back on track.
Okay. I understand you were counsel in a matter that involved relocation in the Family Justice Court where COVID-19 issues were raised and it went on appeal. Can you tell us something about that?
Yes, now I can. The case is ended. So in a sense, I could mention something. It's a challenging case, and certainly I think because of COVID, this case related to a relocation of a mother and child back to the UK. Decision for relocation occurred sometime in October of 2019, went on appeal by the father, and the hearing of the appeal had already concluded sometime in February of 2020. That was really the beginning of COVID-19. And whilst the decision was pending, there were certain other applications the father had made to the court in the meantime after the hearing of the appeal. COVID-19 really took root and became a pandemic. And so the father then filed an application for admission of new evidence before the court, relying primarily on COVID and the differences of the situation of COVID-19 in Singapore and in the UK. And essentially the evidence was admitted, and the appellate court made a decision and upheld the decision of the lower court. And so the mother and child was then due to relocate thereafter and finally be able to return home to the UK. The father then appealed, filed an application for leave to appeal to the Court of Appeal, and primarily relied again on the COVID-19 situation to try and do one of two things. One, to persuade the court that relocation ought not to be granted at this point in time, or in the alternative to that, if relocation was to be granted, then the date of relocation would be deferred until COVID-19 or the pandemic eased off. However, the Court of Appeal did not allow the application for leave to appeal and came to a conclusion that the pandemic is actually an ever-evolving situation, and that no one can really predict how things would turn out in respect of this COVID-19 situation, and that no one can state, with any certainty or degree of certainty, which country is safer than some other country. And certainly even at the High Court appellate level, Her Honor had come to the conclusion that the court ought not to be making orders on relocation depending on a COVID-19 situation at any specific point in time, as the orders may potentially become outdated as the situation evolves. So you could have an order today, for example, which could drastically change because the situation changed the following week or in 2 or 3 weeks' time, and the order would have become outdated. So at the end of the day, the court was not in a position to assess or compare health systems between two different states, or the sufficiency or the quality of the policies put forth by the respective governments in trying to decide a case of relocation, where it's really fact-based and fact-centric in relation to the best interests of the child. So an interesting case, I think it's probably the first case that dealt with a COVID-19 situation where the court considered this new evidence and how that may have impacted a decision or a case, in this particular example, a relocation.
Good. Thank you. Now, Commissioner Gale, can you tell us on a slightly different angle, not the court so much now, but something about your organisation and how it interacts? First of all, tell us about ACE and how it interacts with other similar international agencies.
Thank you very much. Firstly, I would just say, please, my thanks to be invited to be on this panel. I feel very proud to be part of such an esteemed list of panel members. In relation to your question about what is the ACE, what I can say is in March 2018, the Australian government announced the establishment of the Australian Centre to Counter Child Exploitation. It was also announced that that centre, or ACE as we call it, would be led by the Australian Federal Police. The intent was to bring together government and non-government industry partners, law enforcement, civil society, to come together to drive a collaborative national and international response to counter the exploitation of children in Australia. What I can also say is that the ACE is fully operational now in its purpose-built facility that is now operating here in Queensland, Australia. We have already operating within that centre a number of members from the Australian Federal Police, from Queensland Police Service, and a number of our Commonwealth partner agencies and NGOs. We also have co-located with us prior to COVID a number of international or representatives from a number of international agencies, notably from Canada, the Netherlands, and a former member from Interpol. The intent of the ACE is obviously post-COVID to explore further opportunities for collaboration internationally with other partners, not just law enforcement. We are still, despite COVID, engaging with our Five Eyes partners, in particular to look at how in the intervening period we can continue opportunities for that international collaboration. What I would also say, which is significant, I think, as I'll talk more broadly, that the ACE and the Australian Federal Police, or the AFP in particular, have offices that are located or positioned around the world, and they play an integral role in the AFP and the ACE's response to this crime type globally. Through our offices that are located around the world, we work with international law enforcement and NGOs to promote awareness of the issue of online and child sexual exploitation. We also work with our international partners to support international investigations and to enhance capacity development of our partners.
There were reports in the media in April, I think, in Australia, that the AFP had been involved in cross-border operations involving child protection, with 16 arrests in Australia and the removal of 4 children from harm. And yes. I'm not sure if this is the same operation, but in May there were media reports of an ongoing investigation by Australian authorities into the sexual abuse of children in the Philippines, which resulted in the rescue of 3 children and the arrest of 1 woman in the Philippines. So it seems like your work is definitely going on. Are you able to tell us anything about these operations?
Yes, I can. What I can say is consistent with my previous comments is that the ACE and the AFP work very closely with our international partners. And in the Philippines, in this particular instance, the AFP, we have an international post in Manila, and we work very closely with the Philippines authorities and NGOs in that region to detect and disrupt those people that are engaged in sexual abuse and exploitation of children. We work with them to remove those children from harm, and particularly of concern to us is the growth that live distance child sexual abuse has had, particularly in those regions. As part of this capacity development and partnership arrangement that we have offshore, we have seen the establishment in the Philippines of the Philippines Internet Crimes Against the Children Centre, which we call the PICAC. And the PICAC is an international effort designed or established to protect children, and was founded by the Philippines National Police and the National Bureau of Investigations, and also the United Kingdom National Crime Authority. The Australian Federal Police and the International Justice Mission, we've all come together to partner and collaborate in establishment of the PICAC. And it's through the PICAC and its evolution into an international collaboration hub that many law enforcement agencies come together to work to protect children from online harm, from online child sexual abuse. And the cases you referenced before are coordinated through the PICAC. What I can tell you, which might be of interest, is that since the PICAC was established in February 2019, it's undertaken a total of 59 operations, which has resulted in the rescue of 198 victims and 55 suspect and facilitators have been charged. During that time, we've had 3 offenders that have actually been convicted. And what I would say is of those, 21 suspects that have been arrested and charged, and the rescue of 62 victims were the result of referrals coming from Australian-based investigations. What I would also say is through the AFP and our state and territory law enforcement partners in our what we call joint anti-child exploitation teams that are located in each state and territory around our country, that we work very closely in collaboration. And again, the matters that you referred to before, the one in May in particular, that had the 3 children that were rescued from the Philippines, that came as a consequence of that international and interagency collaboration. I can tell you that those children that were aged 6, 11 and 14 were rescued as a result of a referral from the AFP to the PICAC. Sadly, I can tell you that it was an Australian citizen that was actually paying for the live distance child sexual abuse of those victims.
Do you think the sort of lockdowns and people being at home and using the computer more during this time has meant that more children are vulnerable to abuse from adults?
What I would say in response to that, in relation to COVID, we through law enforcement, not just in Australia but internationally, that we have found that COVID has been no barrier to police continuing to target offenders and protect our vulnerable children in our communities, and that will remain one of our key priorities. And what I can say to you is that as we all spend more time working, being at home, self-isolating, not going to work and children not going to school, that presents opportunities for perpetrators of these crimes to look to exploit those children that are obviously spending more time online. What I can say to you is that since March this year, that we have seen, Australian law enforcement has seen that sites that are hosting online child sexual abuse material has actually been crashing because of the significant increase in volume and volume of traffic, I should say, to forums, both in the clear net and the dark web. What I can say to you is that we're seeing that there continues to be a significant increase in the number of files that are being downloaded that contain child abuse material since COVID has occurred. And that's, again, not just what we're seeing or experiencing here in Australia, but what we're seeing at a global level. And I can tell you from an Australian perspective, and this is a very sad statistic, that we have seen an average increase of approximately 163% in activity in the internet of this type compared to the corresponding time frame last year. What I can say is that we're also seeing that online child abuse forums are growing exponentially, that we're seeing that they're having more and more members, some in excess of 1,000, where they're sharing and producing child abuse material. Yeah, I can say to you that it is the exponential increase is of great concern to law enforcement, particularly as these offenders look to continue to get requests for more and more newly produced material and original content. So in answer to your question about are children more at risk, given that appetite is insatiable, yes, is certainly one of the things I would say. I would also say that we're seeing that children are spending an increasing amount of time online and again of concern with often limited adult supervision. What reports received by the ACE from members of the public show that parents are aware of the challenges and are telling us that their children are receiving unwanted contact online. What we have done throughout the COVID period is we know that arresting offenders is not the only solution to this issue. So the ACE, together with the AFP, we are increasing our prevention activities. And what I can say is that between April and June this year, the ACE, together with Think You Know and the AFP, we intensified our efforts for outreach, prevention and deterrence initiatives due to the concerning risk factors that we saw as a consequence of that exponential increase in activity of this nature. What I can tell you about Think You Know, for anyone that hasn't heard of it, that it's a partnership between the AFP, the Commonwealth Bank, Datacom, Microsoft Australia, and it's delivered in collaboration with all state and territory police and Neighbourhood Watch Australasia. It is a program that explores what young people see, say and do online, and addresses some of those challenges such as privacy, self-generated content, online grooming, coercion, extortion, and importantly, how to report suspicious behaviour. Resources on the Think You Know website, including the parent and carer resources and a teacher's toolkit, have been updated throughout COVID just to assist because we know that there is the increased traffic on the internet. What I can also tell you is that as part of our prevention activities, a 7-day online safety challenge was launched by the Minister for Home Affairs, my apologies, in April this year. And the initiative included daily practical challenges, such as learning about applications, learning about games that your children use online, and for parents to help check privacy settings for children and with their devices. We used a series of social media posts to help raise awareness, to educate and encourage parents and carers to undertake preventative measures in relation to their child's online activities. And I guess if there's one message, if I can convey to all parents out there watching this, is please know what your children are accessing online. Please have the conversation with your children, because as I've just sort of mentioned, the statistics are horrifying in terms of what these offenders are doing in the online realm. And, you know, please, it's incumbent upon us all to protect our children, some of whom, you know, are just unable to protect themselves.
Thank you very much, Commissioner. And I guess I don't need to ask you really what keeps you awake at night.
No, I think all the things I've just highlighted, you know, and not being able to, you know, be able to be effective in that fight to counter this really abhorrent and heinous crime.
Good, thank you. Back to the courts then, if I could. Chief Justice Olsterdgren, we know you touched on some of the other things that the court's been doing. What other initiative have the courts been working on during COVID-19? I know you've been busy on a couple of things, and I've heard you quote Churchill that we should never waste a good crisis. I'm quite fond of what John F. Kennedy said, which is the Chinese use 2 brushstrokes to write the word crisis. One brushstroke stands for danger, the other for opportunity. In a crisis, be aware of the danger, but recognise the opportunity. So what opportunities have been revealed by COVID-19 to you and in your role?
Thanks, Di. I think, like all of us, we've learned an enormous amount about the capability of everybody present to be able to use electronic forums. And the most important thing, I think, is the COVID List 19, which I think I mentioned to you. We've actually got registrars at the front end triaging these cases, and they've been able to do an enormous amount of work right across Australia, where they've done about 85% of the work triaging cases within 72 hours. Those cases have gone anywhere from regional Australia to the major cities. and there's been 262 cases within a couple of, with a very short period of time that have been dealt with. They've done about 85%, and 100% of them have been reached within that 72-hour period. And a lot of them have been dealt with right there. If they need any further help, they have been. And so I think the idea of being able to be reactive in a short term has made a huge amount of help to us. We're looking at now invoking the same technology in that same kind of way with early triage to two major important projects, which are an extension of the COVID-19 list into a high risk family violence list. Again, using the same kind of idea of national registrars being able to, at first instance, invoking and doing a risk assessment of these cases, and then assigning them to judges electronically if they need to, right around Australia, to be able to deal with them. The other thing is, of course, contraventions. Contraventions are a major problem with our court and our jurisdiction. I think there's probably the worst jurisdiction I've come across where people, not only parties, but also practitioners are guilty of contraventions on a regular basis. And you make all these orders in the best interest of children, only to find that a lot of the time there is they're not followed. And in fact, there's a major delay in having to deal with those contraventions. So we're looking at those two things. But that's really a preamble to what we're really excited about, which is the COVID-19 list. That's a list which looks at early identification of cases coming into through a new notice of risk. There is an online, I was going to say app, but an online process where people can identify when they first file the level of their risk, and it can be identified very early, and then we can triage those cases appropriately through extra resources the government have given us to be able to identify those cases into certain categories. If you took a traffic light, it would be red, amber and green, and the red and amber, of course, being the cases which are urgent and need requirements very quickly. We have to make sure then that we're able to information share with state and other departments to make sure that the cases are properly resourced from a point of view of how we can help litigants as much as possible. And as we all know, half the difficulty with these cases is once you've got them into your system, you've got to make sure they are resourced and the departments and other agencies are actually properly notified to try and nullify the risk involved. And of course, we then have a very exciting list coming up, which is actually called the Evatt list, named after our first Chief Justice, Elizabeth Evatt. I was able to ring her and tell her about this. We're actually making a list in the Federal Circuit Court, which is going to be go out nationally. And basically, these higher risk cases will be dealt with in the same way as Magellan cases in the family court, where they will be appropriately dealt with and monitored and case managed. We think those things will make a major difference. David Pringle, our CEO, has been heading this up with a fantastic group of people, but also judges have been involved in essentially putting them together. I think it'll make a major difference. We will do business differently after COVID than before. And I would say that a number of our hearings, particularly our regional hearings and our national hearings that need to be done will be done by a national list, which will be electronic in many regards. Regional Australians will be much better off, and I think also vulnerable people will be much better off, particularly those who would otherwise see and have inhibitions about or very great fears about having to actually go to a courthouse. I think access to justice will make a major difference. So we're looking at those exciting projects. They'll be rolled out between now and October. And particularly the Lighthouse Project, I think, will be a really interesting project, which we'll look forward to providing more material about as it comes forward. I think they're the main issues that really have come to pass. We've got new national senior registrars that were appointed recently, and the use of registrars in the courts generally are increasing, which will make a big difference in helping us triage the cases at first instance. So they were the major initiatives.
Thank you. Thanks, Chief Justice. That sounds really exciting for the court. Debbie, I know that in Singapore you've been doing some very exciting things, particularly with the non-adversarial approach to litigation. Can you tell us how you decided to introduce this initiative and how you've implemented it?
Yes, thank you, Diana. You know, this idea of a non-adversarial approach, I think that for the longest time, not just Singapore, but certainly Australia as well, many other jurisdictions, have recognized that family proceedings need to be approached in a different way from civil proceedings. And we had talked about less adversarial. And more recently, we have made a bold step to not just less adversarial, but non-adversarial. And of course, this then can be quite uncomfortable for those of us who have been brought up, raised in the adversarial system. And the reason for this is that the consequences of family breakdown are what parties need to address. It's not about rights and wrongs. It's not about a plaintiff suing a defendant for a breach of a right. They're just there needing a solution because the marriage is broken down, family relationships have crashed, and they need to move on and they can't. So it is a focus away from rights and wrongs to one which is problem solving, where therapeutic justice is going to be adopted. Now, therapeutic justice, or TJ, as we call it affectionately, TJ may seem like a vague, nebulous concept. What's TJ? How do you do it? So what we're doing is we're coming up with a narrative, a common language, so that we know when we talk about TJ, what we mean. So we've got the illustration of, rowers in a boat, and the court processes, the law, the hardware would be the boat. So we got to get the boat right. And then the software would be the actors, the lawyers, the judges, the mediators, the parties, all sitting in the boat. And we need to row in the same direction. So for some of us, we're just naturally TJ inclined. We have those skills. And so even if the boat is an adversarial boat, because you are a TJ inclined lawyer or judge, there are elements of TJ that we've already brought into the system. But it can, of course, work the other way around. You could have a TJ boat, for example, mediation and counseling, but the actors may be just resistant and the software just isn't ready, and we can't all row in that same direction. So what we're doing is we are now engaging the bar. Of course, Mr. Yap is here, a very valuable member of our family bar, and we are encouraging the bar to understand why we need to do this, why children are damaged over time, where the parents don't even realize, and they don't even know that the damage is being done. Years later, when they come to court, the damage has already been done. And we're trying to have upstream measures that will help parents to see that the moment their relationship has broken down, there are leakages of these effects on the children. So upstream, we're asking the lawyers to, get on board and be that counsel for parties to look at the problem and deal with the consequences of breakdown, rather than find that they need to fight as adversaries, in litigation in court. And the thing is that, in Singapore and many countries, you can't get a divorce outside the court. Right? You can't go to the registry to get a divorce. And so you go to the court to get a divorce. And when you go to court, it just feels like you're in litigation, and you're kind of sucked into litigation. So we're trying to change that mindset. And so we're having seminars. In fact, a few days ago, we had a forum where we presented some ideas on what we could do. And this is a consultation phase where the lawyers and psychologists, psychiatrists, everyone involved can bring their ideas back and we can collate them. And in September, we would discuss the ideas. So it's a kind of a co-created system with all who are involved in the family justice system. We are going to start our MDT pilot, and that is our multidisciplinary team, MDT pilot, where we're going to have judges, mediators, counselors, psychologists, and work as a team during the hearing process. So even though it's in court, it's not just going to be a judge being a judge, but it's going to be an MDT, a multidisciplinary team effort. So these are some of them. Of course, I have my work plan speech available if anyone is interested to find out more about what we are doing. Very exciting, but lots of work. And we need certainly to engage people like Yap as well in this endeavor.
I know from experience how making significant changes to legal culture requires a considerable buy-in both from the judiciary and the profession. And that's what you've been talking about. Mr. Yap, what's the position from the profession's point of view?
I think from the profession, it's certainly extremely important. I think the family bar is certainly an important stakeholder in the family justice system. You can't have one without the other, and certainly as Justice Ong had alluded to, we got to get on the same boat. I remember a long time ago when I was a kid going into a canoe, right? Canoeing around Coney Island, around Singapore, in one of these outdoor camps. It was a double-seated canoe, and we saw two people got into the canoe, but lo and behold, they were facing each other. So, you know, that's worse than facing in the right direction, but not rowing in tandem and rowing out of tandem. So that doesn't help also. But I think with the correct mindset, and I think it's about believing in what we do as family lawyers, and if we have to focus on the family and the children, I think that in itself is already a huge starting platform to move away from the constant approach of rights and wrongs. And ironically, lawyers, I think, in the process of representing their clients in the right and wrong, are trying to solve the problem, but in a very different way. You know, we still solve the problem, but I think the problem solving comes in really right at the start now. And I think from the word get-go, when we first meet the client. At that point in time, we have the ability, and I think the influence as family lawyers, to potentially change the course of what may arise from a litigation out of that first meeting. And I think we must realize that we do yield a huge important influence over the client. But I think that's sometimes where the struggle is between the lawyer and the client. As I think, you know, my colleagues out there who are on this webinar would appreciate, right? That's always the challenge. But I don't think it's an insurmountable challenge. It takes time with the client, but it can be done. And certainly I think the idea of therapeutic justice and multidisciplinary approach gives the support to the family and particularly the children who are caught up in the middle of the entire dispute, unfortunately. So yes, I think the profession and the family bar would support the courts as much as the courts have always supported the family bar in the work that the profession does. Yes.
Thank you. Susan, are there any processes, new processes happening or planned in the UK courts, particularly in the family division?
Yes, absolutely. And one of the things I probably should have said earlier is that where we have reformed services in place, we've been much more resilient through this period. So we have reformed services for divorce and for probate. And in both cases, we've been able to work really almost at normal volume. And in some weeks of the pandemic have been reducing the number of outstanding cases because we had people able to work on those remote systems and they were easily accessible to people. We've also got an end-to-end system for public family law, which was rolled out to some courts, but not yet to all. And I think one of the challenges of the pandemic has been, again, we've been able to work much better where that's in place, but there's been a balance to be struck between getting that rolled out much more widely, but in doing that, asking courts that are operating under difficult circumstances to go over a change hump. So we're going to roll that out over the course of the autumn. And again, that really, it does two things. It's not just a digitisation, it also allows people to see material and to interact with each other earlier in the process than normal, which helps people to come to resolution and to identify issues earlier, as well as allowing us to speed things up. We're also continuing to really push for more use of mediation and to look for alternative ways of resolving disputes, particularly in private family law cases. That's something that predated the pandemic but has become more urgent as a result of where we are. And then the final thing, which is really much more of an emergency pandemic response and is less kind of technological and more basic, is we are looking at extending court operating hours. Actually, in fact, we're going to do this. The focus is less in the family jurisdiction for that, for the simple reason that in family, when we look at the amount of work we have to do, we run out of judicial capacity before we run out of physical space, whereas in several other jurisdictions with social distancing in place, we run out of physical space and that becomes our constraint. And so the more we can use the space we have where we do need to have physical hearings, the more quickly we can recover.
Thank you. I mean, one of the things that's come across very much today is that something like this does present opportunities. We're moving along with things that might have taken too much time before there are more resources available. So there've been some terrific opportunities. It's almost time for us to conclude. And I had one question that I thought I might finish up with from somebody who sent it in to ask each of you, and I'll do it in turn. Chief Justice, if you could make one suggestion for others that you think would assist them during this period and this kind of challenge, what would it be?
I suppose it would be planning, having a way forward. The biggest difficulty I think I've found is that we've got to make sure we're not just reacting at every turn, but we've actually got a plan to go forward regardless of the circumstances. And planning, I think, has been a big issue, so we can enjoy a vision going forward.
Thank you. Debbie, what about you from your point of view? What's the one message you'd give?
I think that COVID isn't going to go away very soon, and it cannot be that we are planning only for the short term, and that is why we continue to have remote hearings and work from home, and really the business continuity plan has been really solid. And in this, we are aware that if this is going to go on for the long term, we need to give the support. So better equipment, for example, there was some question there about, if you just use a smartphone for Zoom, it's not so good and so forth. Yes, we need good equipment. So for example, our courts are trying to upgrade to higher capacity devices so that Zoom hearings are smoother, and giving us monitor screens so that we don't have neck aches and so forth. And we need to also train the litigants in person. Of course, we work with the lawyers as well. We engage them regularly about the modes of hearings and modes of operations now. And they do give us feedback on what works and what does not work. So we continue to do that. And I think in the long term, we need to make sure that those who are not represented, and it's a high number for our family courts, they must be on board and they mustn't be left behind just because we've got this new normal and they haven't caught up with the new normal. So we do produce, lots of training videos and circulars and how to do this and that. And as I've said, one of the most important things we feel have worked is the physical Zoom rooms, because at the end of the road, if someone just cannot manage, if there's violence at home, what do? They will come to court. And if there's no physical court hearing, at least we will still enable them to stay there and have a means to have their Zoom hearing from within the court premises.
Thanks, Debbie. Susan, what about you? One message.
Thank you. I think my one message would be that we have to think not just about the capacity of the court, but also keep thinking about how we can change the way that we're working and look further upstream in the family jurisdiction in particular. And a lot of people on the call have talked about that shift to less contentious processes to alternative dispute resolution. And that's something that's been, I feel that's been a burning platform in our system for some time, but the platform's just got a bit hotter. And if we can use this opportunity to really make that shift, I think that would be a huge and important legacy of this crisis.
Thank you very much. TL, what about you from the profession's point of view?
I think we should embrace the changes that will come. I don't think the pandemic or the COVID will go away, like the SARS or the H1N1 in that sense. It will be with us for some time, unfortunately. So I think we look at the opportunity to innovate, to make better use of the resources we now have. Certainly, if you ask me, as it is, there's already a lot of time saving via the Zoom hearings for court hearings. I mean, we're not sitting in court waiting for our turn, right, to have a case called. And that in itself, on a daily basis, saves us a lot of time and certainly saves the clients funds and money, right, realistically. So yeah, looking at opportunities. And I think the last thing is really to try and anticipate so that we are sort of trying to be ahead of the curve as a profession rather than be reactive. I think we should just try to be as proactive as possible so that if and when the changes come, well, we are mentally prepared and we are sort of geared up for it. And that's my takeaway, really.
Thank you. Lisa, what would your one suggestion for others that might assist them coming out of this be? I think you might need to unmute.
My suggestion will be a little different to everyone else's. My recommendation is to parents and caregivers, please know what your children are doing online and who they're engaging with in the online environment. And my second part of that message is to those people who may be watching out there more broadly in the internet. If you're an offender committing these type of offences, we will locate you, we will arrest you, and we will prosecute you.
Thank you. Well, I think that brings us nicely to the end of our period. So can I just thank very much the participants for the time that they've given up and the preparation and effort they've put into this. I think it's been a really interesting webinar, and I hope that those of you who've watched it found it equally interesting as I did. If you want to suggest any themes you'd like us to deal with in our next webinar, please send those through to Law Asia. I think they're going to give you a survey, and please let us know because we plan to do more. So thank you all very much indeed.
Thank you.